Gain insight into the latest governance issues from prominent thought leaders in corporate governance as Drexel's LeBeau College of Business Center for Corporate Governance presents Evidence and Perspectives.
In the public setting, I think that increased public access to the boardroom could be positive as long as it doesn't get carried to an extreme. An extreme would be that all board meetings are taped and made available to anybody who wanted to listen. That would prohibit any conversations about succession, where names are addressed. It would prohibit discussions about acquisitions or divestitures. It would just put a very big restraint on all the things that directors need to be talking about. And in any list of director responsibilities, you'd find all those topics listed right at the top of the responsibilities of a board. And you can't be having those kinds of discussions spread across the airways. So that's an extreme. What is perhaps more reasonable? Perhaps making it easier for shareholders to get something on a ballot. I wouldn't want to make it cavalierly easy, because then any crazy idea could get on a ballot and management has to respond to every idea, and we could end up with 1,000-page proxies, which nobody will read other than the lawyers. So I think there has to be some balance, but things such as expanded write-ups from compensation committees about how they determine compensation and what the basis is for that compensation, which goes to investors, is very positive. And there's no reason why, in my opinion, compensation committees shouldn't be happy to engage in that process. The same thing applies to audit committees, or for that matter, nominating committees or governance committees. Speaking as a director of public companies, I think that the whole issue of compensation has, in the average company, gotten out of proportion. I've never served on a board where the question of both the amount and the nature of the compensation of the senior officers has not been a subject of great concern, great interest, and a great amount of discussion. Never taken lightly. Now, are there cases of aberrant behavior? There's aberrant behavior in every subject matter, not just those related to corporations. So, of course, there's aberrant behavior, but it certainly isn't rampant in the corporate boardroom. It never has been, in my opinion. Have there been cases of people getting what amounts to seemingly unjustifiable compensation packages? Yes. But I've never happily been part of one of those discussions. And I think that the focus on compensation right now is disproportionate to the problem. And the question is, if you're actually going to try to limit compensation, where do you start and where do you end? And how far down the ladder are you going to go? Is it going to be focused solely on corporate executives and not on entertainers and professional athletes and politicians? Or is this going to be purely something that is restrictive for corporations and not for the rest of society? So I think it's a really tough issue. I think like most of the issues about corporate governance, it's honestly best left to the board. And if shareholders don't like things, they certainly have the right to sue. And shareholders and plaintiff lawyers recognize that right, and at least in my business experience, they've never been shy to exercise it.